I'm Mike Farris, co-founder of the Convention of the States Project. One of the most common objections I've heard about the Convention of the States idea is the fear that it will result in a runaway convention. There are 5 clear reasons why this fear is unfounded. First, people misunderstand, in fact, some people deliberately misstate the history of how we got our Constitution. We are told that the Constitution was created unlawfully by a runaway convention that was only supposed to amend the Articles of Confederation. That simply is not historically true. The states called the convention and they told their delegates to render the federal Constitution adequate for the exigencies of the Union, and that's what they did. Secondly, there have been over 400 applications for a convention of the states in the history of the country, and we've never had a convention. The reason we haven't is because there's not been an agreement with 2/3 of the states on what the subject matter should be. Agreement on the subject matter is an absolute requirement to get the process going. And really every constitutional scholar, no matter whether they agree with me in the final analysis or not, agrees on that point. There has to be an agreement on the subject matter to get going. Well, the question is, can they change the process after we get going? Well, there's a case that I litigated that is the closest legal analogy and creates a persuasive precedent on the point. When the Equal Rights Amendment was proposed, it was given originally 7 years for ratification. But Congress tried to change the rules in the middle of the stream. They tried to expand the time by about 3.5 years. I filed the first constitutional challenge to that changing of the rules of Article 5 in the middle of the stream on behalf of 4 Washington state legislators. My case got combined with a case from Idaho and Arizona. We worked together and we won. And the ruling of the Federal District Court, which is persuasive but not binding, is you can't change the rules in the middle of the stream. The fourth reason is that it requires 38 states to ratify anything that gets proposed by the convention. The idea that 38 states would ratify something crazy is simply politically impossible. Keeping in mind that if 13 states vote no, the answer is no, which means if a single house in a state votes no, the answer is no. The idea that something crazy could be proposed and you couldn't find a single house in 13 states to vote against the process is simply not credible. The final and fifth point is that the people will be watching. The people will not let this process run away because the people that were necessary to call the convention will insist that the rulers and the legislators and the members and delegates of the convention obey the law. We protect ourselves by our own political activity. Washington, D.C. isn't the solution, it's the problem. Liberty is being assaulted at every turn while Congress buries us in debt. The Founding Fathers knew this might happen. Article 5 of the Constitution gives the states the power to stop a runaway federal government, a convention of states to amend the Constitution. It's the only solution as big as the problem. It's time to stand up, speak up, and show up. Join us at conventionofstates.com.